The High Court yesterday, the 30th of October 2012, delivered a ruling on whether the court has jurisdiction to review determinations made by the Judges and Magistrates Vetting Board. We welcome the decision insofar as it set aside the earlier orders of stay and enabled the board to resume the vetting of the remaining judges. But for the stay, the board will have by now interviewed the 16 remaining judges yet to be interviewed. And now that the stay orders have been removed, the board will resume the interviews as early as Tuesday next week and hopes to complete the interviews of all the remaining judges by the first week of December. For reason given in its 78 pages judgment, the court has ruled that it has power to review the decisions of unsuitability given in the case of 5 judges whom the board found unsuitable. The Vetting Act states that once the board determines that a particular judge is unsuitable and he or she is informed of the decision of the board, the judge shall, subject only to review, be deemed to have been removed from office. Accordingly, the board will file a notice of appeal anytime today indicating its intention to refer the matter directly to the Supreme Court. At the same time, the board will on Friday apply to the High Court to stay yesterday's decision until the Supreme Court hears and determines the issue of the High Court's jurisdiction. The board feels that the matter be decided at the highest level and as soon as possible. The option that we are now taking recourse to, that is to go to the Supreme Court, is out of respect for the Supreme Court. It is also to give a finality to the process. Otherwise, this process will go through the corridors of court, being argued in the High Court, being argued in the Court of Appeal, which is the normal process, and then finally end up in the Supreme Court. And we do not have the luxury of time in this instance because all these matters need to be settled well before this 4th of March 2013. So what we are doing and what we intend to do is to what we call the leapfrog, and that is go directly to the Supreme Court. And our interpretation of the Supreme Court Act and the rules is that in exceptional circumstances, the Supreme Court would allow it. And what other exceptional circumstances can there be than what is now being posed to the Kenyan public, to the vetting board, to the legal profession?